My name is Joseph Sulpizio. I'm an attorney at the Cuddy Law Firm in the Philadelphia office. Cuddy Law Firm is a multi-state firm representing families of students with special education needs and special education due process matters. In addition to our Philadelphia office, we have two offices in New York, one in Ohio, one in North Carolina, and one in Texas. Just to give a disclaimer prior to starting this presentation, I, as an attorney, am authorized to practice law in the state of Pennsylvania. This presentation is geared towards what is going on in Pennsylvania and special education law as it relates to Pennsylvania. If you're watching from another state, we suggest consulting with a special education attorney licensed to practice in your state and or research the regulations in your state. Also, just so you know, we will be doing Facebook Live events from our other offices as well. So check back on our Facebook page and emails often to see if and when those presentations will be taking place. Additionally, this presentation in no way, shape, or form forms an attorney-client relationship. The purpose of this presentation is to give general information regarding navigating the special education system in light of the COVID-19 school closures, and I cannot comment on specific situations or specific students, but we'll try to address general questions. If you have any general questions, feel free to use the chat on the side, or you can ask them verbally at the end. I will save some time for questions. First things first, I wanted to go over some updates on the stay-at-home orders and school closures throughout the state. Back on March 22nd, Mayor Jim Kenney of Philadelphia issued a stay-at-home order for all of Philadelphia County, effective this past Monday and until further notice. As do most of the stay-at-home orders, there are exceptions, for example, health and safety, going on walks, grocery stores, medical attention, assisting family members, etc., are all exceptions. On March 23rd, Governor Tom Wolf issued a stay-at-home order ordering residents from the following counties to stay at home to help combat the spread of COVID-19. Again, exceptions are grocery shopping, seeking medical care, etc. I just learned that from family members who live in these counties that it was expanded last night to add Lehigh and Northampton counties. But prior to that, it was also Bucks, Chester, Delaware, Montgomery, Monroe, which is the Poconos, and Allegheny, which is Pittsburgh area. And as I stated, now includes Lehigh and Northampton. So what are we going to cover and how are we going to cover it? I kind of like to follow this chronologically up to the initial U.S. Department of Education guidance that came out back in on March 12th, and kind of take you up to where we are today. Also want to give you some recent guidance, including a Senate bill that just passed the House and Senate and PA legislature today, is now waiting Governor Tom Wolf's signature. That's also going to have some impacts on special education. My understanding is it was just passed yesterday. And also, just prior to logging onto this Zoom, I was listening in on the School District of Philadelphia virtual school board meeting where Superintendent William Hite was giving updates on what the School District of Philadelphia is going to be doing in the coming weeks to offer remote learning to all of its students. First things first, an update on the school closures in Pennsylvania. So on March 23rd, 2020, Pennsylvania Department of Education, or PDE, announced that all schools throughout Pennsylvania will remain closed through at least April 6th. Best case scenario, the school doors would open back up on April 7th without students. It would allow 2 days for school staff to go in to prepare for reopening, and then students would return on April 9th. This is the best case scenario, as the announcement repeatedly indicates that this timeline is subject to an extension by PDE based on the situation at the time. In looking at other states throughout the country, I have a brother-in-law who is a teacher in Kansas. Kansas already announced that they are closed through the end of the semester and are now preparing for remote learning for the rest of the school year. Not sure if Pennsylvania is going to go in that direction. I don't think Pennsylvania Department of Education knows if we're going in that direction, because as you know, this is a very fluid, unprecedented time, and we will be monitoring it daily. What I'd like to go over next is the initial U.S. Department of Education, March 12, 2020, question and answers on providing services to children with disabilities during the coronavirus disease outbreak. This document, while it was intended to seek clarification, might have caused more confusion than anything. As a result of this document, many school districts who had initially intended to provide remote learning kind of pumped the brakes because of the wording. So I'll go over this now, and then we'll also go over the supplemental fact sheet that the U.S. Department of Education issued within the past week that fortunately provides some much needed guidance and seems to be pointing many school districts in the right direction. The March 12th guidance asked the question, is an LEA required to continue to provide a free, appropriate public education to students with disabilities during a school closure caused by the COVID-19 outbreak? For anybody, just because I used a lot of acronyms just now, an LEA is a local educational agency. Think school district, think charter school. In Pennsylvania, a charter school is an LEA. It's responsible for providing a FAPE or free appropriate public education to its students. In some other jurisdictions, some other states, charter schools fall under the umbrella of a school district. So that's one thing to note if you're listening to this from outside of Pennsylvania. And a FAPE is a free appropriate public education. The IDEA, which is the Individuals with Disabilities Education Act, Section 504 of the Rehabilitation Act, and Title II of the Americans with Disabilities Act, none of them have any clear or any guidance on what happens when there's school closures for extended periods of time. What the U.S. Department of Education said in its initial guidance is that if an LEA closes its school to slow or stop the spread of COVID-19 and does not provide any educational services to the general student population, then an LEA would not be required to provide services to students with disabilities during that same period of time. A perfect example of this is a snow day. When a school is closed due to a snow day, they're not providing services to any student, special education or otherwise, except we're looking at a much longer closure here. Essentially, what it means is if a school district doesn't provide services to anybody or instruction to anybody, then they're not required to provide services and instruction to students with an IEP. The U.S. Department of Education also indicated that LEAs would be required to make an individualized determination as to whether compensatory services are needed. What this means is when the crisis is over, when schools open back up, an IEP team from a school district needs to make an individualized determination case by case, looking at the student who was not provided services, not provided instruction, and determine what do we need to do to compensate the student. We're not talking about monetary. We're not talking about cutting a family a check. We're talking about, okay, do we need to provide the student additional speech language therapy? Do we need to provide the student additional tutoring after school? Those are examples of compensatory services. What parents may want to consider doing, what families may want to consider doing is keeping track right now. What is my son or daughter getting versus what does the IEP require? Say the perfect example is, and I'll just use speech therapy because it's the easiest. The student is supposed to be getting an hour a week of speech language therapy. During this closure, the student's getting none. The school eventually decides to do remote learning. They have a speech language therapist do teletherapy with the student, but they're only doing that 15 minutes a week. What you should be doing is keeping a notebook, keeping an Excel sheet, keeping tabs. The week of blank, my son or daughter received this. This is what the IEP required. So that way, when this crisis is over and you meet with the IEP team, you show that to them and say, this is what he was getting. This is what he was supposed to get. So there can be a discussion about whether compensatory education services are required. The U.S. Department of Education said that if an LEA offers alternative means education, such as online, to its students, it must ensure that students have equal access to the same it must ensure that students have equal access to the same opportunities to special education students, including the provision of FAPE. So if you provide online instruction, you can't provide just the general education, non-special education students and exclude the special education students. You have to provide it to all. And not only do you have to provide it to all, but you have to be ensuring that the students with an IEP are being provided a FAPE at the same time. So say, for example, a school district issues a Google Chromebook to all of its students. While that may work for the general education students without an IEP, while it may work for many of the students with an IEP, you may have a student who is nonverbal, low-functioning autism who does not know how to use a Google Chromebook, who is limited to the point where listening to a teacher that is online, that's without accommodations, it might be useless to the student. So the FAPE obligations apply to this student during this time once the school district provides alternative means of education. So they need to be accommodating the student, whether it be providing training to the parents so the parents can help the student access the technology, making up compensatory education services when this is all over. Those are types of things that need to be decided on an individual basis. Another question that the U.S. Department of Education posed is, must an LEA provide special education and related services to a child with a disability who is absent for an extended period of time because the child is infected with COVID-19 while the school remains open? I'll only briefly touch upon this because here in Pennsylvania, all the schools are closed until at least April 6th. This would apply in a situation where, say, a student got infected with COVID-19 and began missing school, say, March 1st, and the school didn't close until March 15th. We're talking about that student who missed those 2 weeks of instruction during that time, that type of thing. So the short answer is yes, an LEA must provide instruction to that student who's out due to COVID-19 while the school remains open. It's very similar to a case where a student needs homebound instruction due to an injury, due to a sickness, etc. And what the U.S. Department of Education said is that if a child with a disability is absent for an extended period of time because of a COVID-19 infection and the school remains open, then the IEP team must determine whether the child is available for instruction and could benefit from homebound services such as online or virtual instruction, instructional telephone calls, and other curriculum-based instructional activities to the extent available. It also indicated that schools should consider health guidelines to assess and address the risk of transmission and the provision of such services. For example, phone online versus in person. In these times, if a student was infected or even if nobody's infected, my suggestion would be is for families not to push school districts for in-person instruction or for people coming into the home. Across the country, we're stressing like crazy social distancing. We want to be part of the solution where we're working with school districts to come up with remote learning opportunities versus putting people at risk. Just as families may be uncomfortable bringing somebody into the home that they don't know if they've been infected or whatnot, that person probably feels equally as uncomfortable going into the home as well for those exact same reasons. So that's something to keep in mind. The other thing the U.S. Department of Education indicated was that if that child who is out because they're sick with COVID-19, if that child does not receive services after an extended period of time, a school must make an individual determination as to whether compensatory services may be needed, just as we had indicated before in the other scenario. So what were the initial takeaways from this initial U.S. Department of Education guidance? One thing, which I'll probably mention a couple of times during this presentation, is acting in good faith with the school districts. This is unprecedented time. Nobody has all the answers as to how we're going to get through this with regard to education. Act in good faith with the school districts. If the school is closed and they're offering remote learning, even if you know right off the bat, there's no way this is going to work for my son or daughter with an IEP, don't just automatically say no off the bat. Try for a few weeks. If it's not working, send a letter, always do something in writing, send a letter explaining why it's not working for the student, because this could cause issues later on down the road if you don't at least act in good faith with the school district. For example, if you seek compensatory services later on, if you just quickly tell the school district, no, I'm not agreeing to that, or I'm not going to try that, that could run into issues later on down the road if you're seeking compensatory services. If you act in good faith with the school district, it doesn't work, you tell the school district it's not working, and then the school district doesn't accommodate, then you're basically creating a paper trail then for yourself, showing that you acted in good faith. One other major takeaway from this guidance is it in no way, shape, or form addressed the deadlines as required by the IDEA, such as IEP meetings, reevaluations, initial determinations of eligibility, those types of things, which caused a lot of confusion amongst the country. This was later clarified in the March 23rd supplemental fact sheet, which we'll get to in a few minutes. So shortly after that Department of Education guidance on March 12th, the Pennsylvania Department of Education issued a very similar Q&A or guidance on March 15th. First, it notified school districts that will not penalize school districts that do not meet the minimum requirements of 180 school days as a response to COVID-19 response efforts. It also indicated that schools are strongly encouraged to plan possible adjustments to provide as much instruction as possible. School districts have the option to continue distributing no-cost meals while schools are closed, but they are not required to. One school district that is continuing that right now is School District of Philadelphia with the no-cost meals. One of the questions that the PDE posed are school districts required to provide any type of instruction during the closure of school due to COVID-19 response efforts, and they said no. Whatever decision is made, LEAs must ensure access to learning for all students with a particular attention to FAPE for students with disabilities and ESL services for English learners. The next question they posed is a school required to continue to provide FAPE to students during school closures? This is where they fell very much in line with the U.S. Department of Education. They said if a school is closed due to COVID-19 and does not provide any educational services to the general student population, they are not required to provide services to students with disabilities during the closure period. So basically right in line with what the Department of Education said 3 days earlier. And then if a school is closed due to COVID-19 and does provide any educational services to the general student population, schools must ensure that students with disabilities have equal access to the same opportunities, including the provision of FAPE. So very much in line as well. They also indicated to the greatest extent possible, the student shall receive the special education related services in their IEP. Once school resumes, the school districts must make an individualized determination on whether and to what extent compensatory education services are needed. So the bottom line again, which I had talked about before at length, and I'll just briefly state again, is to keep track of what the student is supposed to be provided versus what they were getting during the school closure. So what was kind of the domino effect after the U.S. Department of Education guidance on March 12th and the PDE guidance on March 15th? It was kind of what you would expect. It was all over the place. There was a split in school districts on whether to provide educational services to any of its students. The Philadelphia Inquirer did a nice article on March 15th, which kind of showed the polar opposites of what school districts were doing. For example, Lower Merion School District on the main line was already planning to begin a remote learning program for students that Wednesday, and we're working to provide families with access to technology. Meanwhile, the Upper Darby School District, which is just outside Philadelphia, indicated that the district's plan to provide educational opportunities to students was on hold in light of the new guidance from the Pennsylvania Department of Education. A spokesperson for Upper Darby said that the schools were not required to provide education to students during the closure, and if they did, they must provide full access to students for full access to education for all students, including students with disabilities. And the spokesperson said, quote, "Given our current resources and lack of appropriate funding, we cannot guarantee equal access to the educational opportunities we have created within these guidelines." Unfortunately, this was the response by a lot of school districts, not just in this state, but in many states, is based off of the guidance that they received from the U.S. Department of Education. We can't guarantee equal access in order to essentially avoid putting ourselves in litigation's way by not providing a FAPE to students. We're just not going to provide education to anybody. School District Philadelphia, also prior to the guidance, had initially indicated that they were planning on providing some type of remote learning. Once the guidance from PDE and the U.S. Department of Education came out, all staff were told to stop. In fact, there was an email to School District Philadelphia principals on March 17th where principals were told that teachers are not allowed to do remote instruction. And it even said, quote, to ensure equity, remote instruction should not be provided to students, including through the internet technology at home, by phone, or otherwise. And as I indicated before, there were many other districts across the state and country who rejected providing education to any of its students, some quoting the equity concerns while others staying silent on the rationale behind it. Fast forward about a week to March 21st. Fortunately, we received a supplemental fact sheet from the U.S. Department of Education, which cleared up a lot of the ambiguity that came about because of the first Q&A that they had issued. In this one, the Secretary of Education stated that, quote, that the school districts must, or that the U.S. Department of Education must address a serious misunderstanding that has recently circulated within the educational community, as school districts nationwide take the necessary steps to protect the health and safety of their students. Many are moving to virtual or online education. Some educators, however, have been reluctant to provide any distance instruction because they believe that federal disability law presents insurmountable barriers to remote education. This is simply not true. We remind schools they should not opt to close or decline to provide distance instruction at the expense of students. To address matters pertaining to services for students with disabilities, rather, school systems must make local decisions that take into consideration the health, safety, and well-being of all their students and staff. To be clear, ensuring compliance with the Individuals with Disabilities Education Act, Section 504 of the Rehabilitation Act, and Title II of the Americans with Disabilities Act should not prevent any school from offering educational programs through distance instruction. So this was some very much needed clarification from the U.S. Department of Education and the Secretary, Nancy DeVos. Basically, they saw the impact that the initial guidance had, the ripple effect, where many schools across the country were opting not to provide any education, or if they were providing education, it was these learning guides, these optional learning guides that were on websites and whatnot, which is not educating the students. It's more so personal educational enrichment for families that opt to do so. So this guidance did definitely shed some light on the fact that school districts should not be using this as a scapegoat to not provide education to anybody. The Department of Education also indicated that they recognize the exceptional circumstances that may affect how all educational and related services and supports are provided. School districts must remember that the provision of FAPE may include as appropriate special education and related services provided through distance instruction, provided virtually, online, or telephonically. And they reiterated that due to the global pandemic and resulting closures of schools, there has been inevitable delay in providing services or even making decisions about how to provide services. IEP teams must make an individualized determination whether and to what extent compensatory services may be needed when schools resume normal operations. So they reiterated that same point from their March 12th guidance regarding the compensatory services being assessed on a case-by-case basis. Another crucial point of the new guidance from the U.S. Department of Education is the IDA timelines. What the U.S. Department of Education indicated was that they encourage LEAs to work with families to reach mutually agreeable extension of time if appropriate. Districts cannot unilaterally extend IDA mandated timelines. One thing to always be on the lookout for in these trying times is if a parent or a family member is told by a school district that due to the closure, the district's not required to complete the student's reevaluation or not required to convene an IEP meeting, etc. Those are simply not true. unless a family mutually agrees to extend timelines, all timelines remain in full force and effect. And I'm going to give some examples here. Let's first go over IEP meetings. The regulations say that an IEP team must meet and develop an initial IEP within 30 days of a determination that a child needs special education related services. That still applies unless the family mutually agrees with the district to extend that 30-day timeline. According to the IDEA, IEPs also must be reviewed annually. That still applies. District made an IEP April 1st of last year. They haven't reconvened IEP meetings since. Under the law, they need to hold another IEP meeting, develop next school year's IEP by April 1st of 2020. School's not open right now. School can't just say we're not open, we can't hold an IEP meeting. The year is 2020. There is Zoom, which we are on right now. There is Skype. There are telephones for families and school districts that don't have access to video conferencing. There are alternative means to hold a meaningful IEP meeting. The regulations even indicate that parents and IEP teams may agree to conduct IEP meetings through alternative means such as video conferencing or conference telephone calls. Another option to be in mind of as well under the regulations, the parent of a child with a disability and the public agency may agree to not convene an IEP team meeting for the purpose of making changes and instead develop a written document to amend or modify the child's current IEP. This is with regard to a child's current IEP, not with regard to a new annual IEP. Say, for example, you are going through the school year and the district wants to make a change to the IEP. They want to add an extra 30 minutes a week of occupational therapy because the student's struggling in fine motor skills. They can't just go ahead and make that change without holding a meeting. The district would need to hold a meeting, but a parent could agree if the school district puts in writing that we would like to change the IEP to add 30 minutes of OT or occupational therapy, a parent could agree to amend the IEP without the need for an IEP meeting. This always needs to be done in writing with the parent's signature, but that's something to keep in mind if a modification or amendment needs to be made to the IEP without needing to convene a full meeting. Another thing to be aware of is initial eligibility determinations. The regulations state that initial evaluation must be conducted within 60 days of receiving parental consent under the IDEA or within the state established timeline within which the evaluation must be conducted. This also applies to reevaluations as well. It's 60 days from when the parent signs the permission to evaluate consent form up until when the evaluation report needs to be completed and provided to the parent. It's 60 days. Here in Pennsylvania, there's one exception to that. It's excluding summer months. This is ignore the COVID-19 closures for a second. Excluding summer months means during the school break, during the summer, that 60-day clock stops. I could argue why it shouldn't, but the rationale behind it is that many school staff members, such as occupational therapists, school psychologists, speech language pathologists, do not work over the summer months. It's not 60 school days. It's 60 calendar days excluding summer months. As we sit here right now, this Thursday, when school should be open, but it's not because of COVID-19, today counts towards that 60-day timeline. It's not excluding winter breaks. It's not excluding holidays. It's not excluding snow days. It's summer months only. So look at your school's academic calendar prior to the COVID-19 closures. The last day of school, let's say, is June 6th. The first day of school for next school year is September 1st. Between June 6th and September 1st, those are the only days excluded. So even if school stays closed through the rest of the school year due to COVID-19, that 60-day clock continues. So that's something to be aware of. If a parent has signed a permission to evaluate consent form and there's a pending reevaluation, a district should not be telling you, we don't have to complete this because we're closed right now. That's not acceptable. Now, the district might have to do some type of abbreviated reevaluation because they can't have face-to-face with the student due to the social distancing. Some testing, I've seen, especially school psychologists are starting to do some virtual testing. For example, a student who's being tested for a learning disability in reading, it's possible that that evaluation might be able to take place via video conferencing. However, it's a case-by-case basis, because a student with an intellectual disability who needs nonverbal IQ testing, that student probably is not going to be able to do the testing via video conference. So it's really a case-by-case basis. What some school districts are doing right now is they're doing what testing they've done so far, what they can do remotely, and then a records review for the rest. What I hope these school districts do is, once schools open back up, they will then supplement the reevaluation with all the testing they could not do before. If the districts opt not to supplement the reevaluation with whatever else needed to be done, they're opening up themselves to litigation or through requests for independent educational evaluations. An independent educational evaluation is a right that a family can utilize, where they submit a letter to the school district stating that I disagree with the district's reevaluation because it wasn't comprehensive or whatnot. I'm requesting an independent educational evaluation at district expense, meaning an evaluation done by somebody not affiliated with the school district who has no bias to do an evaluation. When a parent requests an IEE, the school district has one of two choices. They either need to approve the request, or they need to file what's called a due process hearing against the family to show a hearing officer that the reevaluation was appropriate and comprehensive, and therefore independent evaluation should not be ordered. If school districts aren't going to supplement their reevaluations once the COVID-19 closures are over, I can see an influx of IEE requests occurring. Something also to be aware of with reevaluations is that a student must be reevaluated at least every 3 years. For students that are classified with intellectual disability here in Pennsylvania, it's every 2 years, unless the parent and the public agency agree that a reevaluation is unnecessary and you obtain the parent's consent in writing to waive the annual reevaluation. One thing that I anticipate is that we may see an increase in requests from school districts for parents to waive a reevaluation due to the COVID-19 closures. One thing to be aware of, though, is that a student's ever-changing special education needs warrant reevaluations to determine their most current needs. So, for example, a student's needs and abilities change every year. Relying on an evaluation that's 3, 4, 5 years old because a parent decided to waive the reevaluation may not give an accurate picture or snapshot of where the student's needs are now. If you're relying on a reevaluation from 3rd grade, the student's in 7th grade now, I can almost guarantee you that students' needs have changed, just as everybody's needs have changed over the years. So that's something to be aware of about not waiving a reevaluation. Something you may consider is agreeing to a short extension of the 3-year reevaluation. Say, for example, the student was last reevaluated in May 2017 or May 2020. District needs to get it done by May 2020. Maybe agreeing to a short extension stating, you know, I agree to let the district complete the evaluation by the end of June 2020 or by the first month of school in September. That's something to consider versus waiving the reevaluation altogether. Due process hearings. The regulations state that when a parent files a due process complaint, a school district must convene a resolution session within 15 days of receiving notice of the parent's complaint, unless the parties agree in writing to waive the meeting or to use mediation. While the IDEA specifically mentions circumstances in which the 30-day resolution period can be adjusted, does not prevent the parties from mutually agreeing to extend the timelines because of unavoidable delays caused by the COVID-19 pandemic. This was guidance from the U.S. Department of Education. It also indicated that although a hearing officer must issue a decision within 45 days after the expiration of the 30-day resolution period or an adjusted resolution period, a hearing officer may grant a specific extension of time at the request of either party to the hearing. The long story short of this is school districts and parents, is that due process is still available during these trying times. There has been no stoppage in parents' ability to file due process complaints or school districts to file due process complaints. While parties can request continuances, these timelines are still in effect unless a party requests an extension. Parties can still hold resolution sessions via video conference, via phone. Hearing sessions, I just had a hearing this past Monday that was done telephonically. Those are still occurring. So due process is still an available mechanism for families who believe that their student was denied a FAPE previously or is currently being denied a FAPE as well. In special education due process matters, there's a 2-year statute of limitations, so families can actually go back 2 years from the date that they file alleging claims of failures of free appropriate public education. So even while schools are closed, there may still be issues from the students' previous school years that come into play. So what was the impact of the new guidance from the U.S. Department of Education on March 21st? Fortunately, most districts, or more districts, are now turning to provide instruction remotely. There's still plenty of work to be done. School District Philadelphia just announced on March 23rd that is developing a remote learning experience, which will include enabling access to district purchased online learning platforms. Just this morning, I listened to a radio podcast where it was a brief interview with Superintendent William Height from the School District of Philadelphia, and just wanted to mention a couple things that of importance that he had noted during this radio interview. He mentioned that the district is continuing its meal distribution program at 49 schools. They are open Monday and Thursdays from 9 a.m. to noon. It had previously been more days than that, but they have lowered that because of the fact that it's only open 2 days now for 3 hours per week. Students can now pick up 6 grab-and-go meals at a time. Locations are available on the School District of Philadelphia's website. He was also asked the question about the March 17th email that went out to the school principals, basically forbidding them from providing any types of remote instruction. He had noted that the memo should have been worded better. Said the district sent the memo in response to the initial guidance from the Department of Education, Pennsylvania Department of Education. And the district did not want the staff grading materials, taking attendance, etc. But the new guidance from the U.S. Department of Education clarified some things. One thing he mentioned, which was a little bit strange, and I put in bold here, he wants teachers to communicate with students and teachers. He wants teachers to communicate with students, and he wants those teachers to voluntarily answer inquiries from students and families. I thought the voluntarily answer inquiries was interesting choice of words, as it sounds like they might not be forcing or instructing teachers to respond to inquiries from families, but hoping that they do. He also said that the district is looking to provide technology and internet so students can participate in remote learning. He also specifically referred to Chromebooks as being one of the devices. He says that he is looking for this to be up and running within the next couple of weeks. Based off of his opening remarks and presentation from 5 o'clock today during the school board meeting, I'll get to in a moment, but he did give some additional clarifications on what he's going to be doing with that, or what the district's planning right now to do with that. Another big update is that yesterday, the Pennsylvania House of Representatives and Senate voted to amend Senate Bill 751, which is Senator Aument's Teacher Evaluation Reform Bill. It was passed to include emergency school code language addressing the COVID-19 shutdown. The bill has now been presented to Governor Wolf, and many expect that he will sign it. The bill provides for some of the following. For example, it's going to waive the 180-day requirement for all schools to be in session. It's going to waive the minimum number of days of pre-K instruction required. It's going to allow the Pennsylvania Department of Education to increase the allowable number of flexible instructional days. It's going to give the Secretary of Education the power to waive career and technical education program hours, the use of performance data and professional employee evaluation systems, and the 12-week student-teacher preparation program requirement. No employer or any school entity can receive more or less compensation because of the COVID-19 pandemic. School entity employees will experience no loss of retirement benefits due to the COVID-19 pandemic. School entities are required to provide written notice to the parents of each special education student of their plan for ensuring each student receives a free, appropriate public education. Just wanted to highlight that one for a second because that one's very major when it comes to students with IEPs. So basically, the school districts are going to be required to provide a NOREP, Notice of Recommended Educational Placement, to each parent of students with special education, laying out their plan of ensuring that each student receives a free, appropriate public education during this time. What I hope will not happen is boilerplate NOREPs being sent out to an entire school district's every single student is going to receive a copy and paste, because as we stress in the special education field is that not any two students are the same. Every student's different. It needs to be an individualized program. So each NOREP needs to lay out what that student requires to ensure that they receive a FAPE during these times. The bill also states that each school entity must make a good faith effort to provide for continuity of education during the closure, submit that plan to the Department of Education, and post it on their website. Pennsylvania Department of Education must apply to the U.S. Department of Education for a waiver of testing requirements. Professional educators' continuing education compliance is extended by 1 year. And non-public schools do not need to meet the minimum instruction time and do not need to administer standardized achievement tests. It also ensures that no school will see any loss in subsidies, reimbursements, allocations, tuition, or other payments from PDE or another school entity as a result of actions taken by the secretary. So, for example, if a school district is funding a student at a private placement, such as an approved private school, those approved private schools will still receive 100% of the tuition for the school year. Also, I wanted to briefly go over some of my handwritten notes from the Superintendent Height's opening remarks and presentation during today's school board meeting, which might actually still be ongoing. When I left, they were going over what's going to happen with asbestos and lead fixings through multiple schools. But at the beginning, Superintendent Height talked about the Chromebooks. He indicated that the district is seeking ordering up to 50,000 Chromebooks, which will cost about $11 million. They said that they're currently in the process of reaching out to schools to determine how many Chromebooks they need per school. For example, if a family already has a tablet or a Chromebook or a working laptop and internet access, one might not be necessary for that family. But they're figuring out right now it's going to be approximately $11 million, and they're also seeking private funding to help offset the cost of the district. What's been going on the past 2 weeks is that there's been these optional learning guides that are available on the School District of Philadelphia's website, and also have been available for print pickup at the grab-and-go meal sites. These have been optional and not required for students to participate in. They've only covered previously learned materials, not new materials. Superintendent Height indicated that there's going to be new guides available on. They became available online yesterday, and starting Monday, they'll be available at all grab-and-go sites throughout the city. And it will cover about 10 days worth of instruction, hopefully to get us then to the point where the Chromebooks will be available. The Chromebooks, he indicated, though, the plan is right now that they won't be distributed until April 13th through 17th. So that's the week right after Easter. He says that the Chromebooks will give access to optional online tutorials, which should reinforce skills and introduce new skills as appropriate. He indicated that there will be online training tutorials for families to familiarize themselves with the applications on the Chromebooks. He also mentioned that while graduation ceremonies for seniors may be pushed back, the district is hoping to do everything they can to make sure that these graduation ceremonies still take place, even if it's at a later date, just because of the importance and for each student. I'm sure everybody here probably remembers their high school graduation day in some shape or form. He doesn't want to take that away from students if at all possible, even if it requires holding it at a much later date. Some final takeaways from everything we just talked about, and before I open up the Zoom to any questions. The things that I've heard throughout the last 2 weeks, I just want to reiterate, is stay calm, be part of the solution during this pandemic. Don't contribute to the panic. Don't go to the supermarket and buy out all the toilet paper. Practice social distancing, remain calm. As I stated before, act in good faith with the school districts. If they offer remote learning supports, don't automatically reject them. The proposed supports are not working for your individual student, let the district know in writing. Keep track of what the student's receiving versus what they're supposed to receive per their IEP. Prior to the closing, a student may be entitled to compensatory services at a later date. The Pennsylvania Office of Dispute Resolution issued a statement that the due process mechanism for families has not and will not be suspended. One thing I just want to note is that FAPE violations against the school district involve current and past allegations of any alleged FAPEs, as I indicated, going back 2 years. If you believe that your student or someone you know, if that student was currently or is not receiving an appropriate program, consider consulting with a special education attorney. You may want to check with an attorney on how their fee arrangement works. Some special education attorneys work on a sliding scale. Some others do not and require flat retainers. Here at the Cuddy Law Firm, our doors remain open. We continue to advocate and fight for students with special education needs. We also work on a sliding scale to determine what, if any, fee we charge families that give us a call and have us review the educational records in order to represent them in a due process matter. Some cases wind up being no fee to the family. Also, finally, I'd like to give a shout out to the Parent Special Education Bar, both here in the state of Pennsylvania and throughout the country, as well as advocacy organizations throughout the country and also in Pennsylvania, who have been lobbying nonstop for the continuation of special education rights for students with special education needs. Just recently, we signed on to a letter sent to Governor Wolf that was drafted by one of the nonprofit organizations in the state, stressing the importance of continuing to provide a FAPE to students through this COVID-19 closures. We've also seen that the U.S. Department of Education received much letters, correspondence from organizations and attorneys regarding that initial guidance and kind of the impact it had, the negative impact it had. And we believe that in part led to the secondary guidance that we received on March 21st that really clarified that school districts should not be opting to refuse to provide services to all students in order to get around their FAPE obligations to students with IEPs. So we really just want to take a time to applaud everybody out there that's been, families, organizations, attorneys who have been continuing to advocate during these trying times. At this time, I will answer any or try to answer any general questions that anybody may have. You can either type it in the bar, since there's only a handful of us right now. If you're comfortable doing it with your microphone, that's fine. If it's something where you prefer to do privately, Amanda indicated in the chat bar my email address and direct dial number. Feel free to email me and give me a call, and I'll try to answer those questions as well. But I'll open it up to questions now if anybody has one.
Hey. I wanted to, so I am an actual visual learner as well. Is there any way we can get a copy of what was discussed in our email, or?
Sure. Are you talking about are you talking about, so what I can do, if you'd like, what I can do is I will, Jasmine, and if anybody else wants to throw their email address in the chat bar, or Jasmine, I already have your email address. If you want to throw your email address in the chat bar, or you can just send me an email so I have yours, I can give you the links, or the PDFs to the recent guidance from the initial guidance, if you want it, from the U.S. Department of Education, the new guidance that we received, the PDE guidance, the guidance from the Office of Dispute Resolution, those types of things. I don't have the presentation in like a PowerPoint or anything like that. It's just kind of my own chicken scratch. But I can certainly forward the documents that I was referring to throughout. I could send you those hyperlinks or those PDFs.
Awesome. Thank you.
No problem. Anybody else?
Hey, Joseph, this is Cindy Dooch. I'm with the Appeal Center. We're the Parent
Hi, Cindy.
Training and Information Center for Pennsylvania. Regarding the initial Q&A that was sent out by US DOE with the 6 questions, when they referred to a student who was ill with COVID-19 and would be at home, they referred to homebound instruction and not instruction in the home. Would they be using homebound because the child was sick and because of the disability did not need instruction in the home? I just wondered why they referred to it as homebound.
Homebound, so the difference between homebound instruction and home instruction are very similar. Home instruction would be for a student who, what would be a good example? Home instruction would be for a student who may have cancer or some type of disability where it's going to be a very extended period of time. You know, the student may never be able to access their curriculum in a school, in a bricks and mortar school. They may always need home instruction. Homebound instruction is the term used where it's a very limited, is typically an acute injury, say, you know, a broken back, for lack of better words, or COVID-19, where, knock on wood, it's a short-term sickness or injury. With homebound instruction, and I don't have the regs in front of me, but with homebound instruction, you need to obtain a doctor's note, and then basically it goes for, I'm just using a date here, but 30 days, and then at the end of 30 days, the school district needs to determine whether the student continues to need homebound instruction. They might need another doctor's note to then extend it, etc. So the difference between basically home instruction and homebound instruction is homebound instructions for the more temporary short-term disabilities where a student may need a doctor's note and then you keep reassessing. So that's really the only difference between homebound and home instruction. Did that answer your question?
Yeah, kind of. I wondered why, the secretary referred to, a child who receives special education,
Mm-hmm.
which when we think of, instruction in the home as a placement, that she referred to the instruction that the student would be getting as homebound instead of instruction in the home.
Yeah,
I was just curious. It's probably not, like you said, it's not.
Yeah.
It's irrelevant now anyway. But I was just curious.
I'm not sure what's behind Betsy DeVos's mind either. The only thing I could say is that homebound instruction, my guess is, well, we're still learning more and more about this disease every day. And I think one thing that anybody here who's a parent, including me, who has a 6-month-old, that's very reassuring, at least, is that the COVID-19 virus seems to have a much better success rate, for lack of better terms, but it's not having as much of an impact on young children and students, children under 18, where the death rate has been quite low, which is reassuring from a parent's perspective. So the hope is that students who get it will go through the symptoms and then recover. So perhaps the reason why she's using homebound instruction is because versus an illness that may take, or a disease that may take years to recover, it's more of a short-term disease. So that would be my best
Okay.
guess, but it's just guessing.
Yeah, thanks a lot.
No problem. Any other questions? And I will certainly email the DOE info and PDE guidance to the two individuals that threw in their email addresses. If anybody else would like it before we close out, or if after we close out, just feel free to shoot me an email and I will forward it along to you as well. If there's no other questions, I'll let you all go about your self-quarantine and go have dinner, and hope everybody stays safe and we'll get through this. Have a great night.
Thanks, Cuddy. Thanks.
Thank you.